In the case of Butterworth and Independent Australia Services, the tribunal considered whether an employee, Mrs. Butterworth, had been discriminated against by her employer. She was an employee that had been working at IAS for approximately 7 years, and she had sustained a workplace injury to her neck and shoulders working in their call centre, and was on the phone day in, day out. The insurer accepted her workers' compensation claim, and then she was put on to a return to work plan where her duties were modified. In bringing this claim, Mrs. Butterworth set forward that she had been terminated due to her disability, and that in fact the employer should have made reasonable adjustments, including redeploying her to a different section of the business. She was, as I said, in the call centre, but there was also a finance team and an inquiries team that both had customer service officers. Ultimately, the tribunal found that she had been discriminated against and that reasonable adjustments should have been made by the employer, and that IAS was focusing too much on the workers' compensation elements and trying to get over the threshold of 52 weeks of a return to work plan, and not focusing enough on its discrimination obligations or anti-discrimination obligations.
And this is a mistake or difficulty that employers often face. The obligations under workers' compensation and disability discrimination are separate and distinct. There is interrelationship between them, but the obligations you have to go through in relation to considering reasonable adjustments, etc., apply regardless of whether it's a workers' compensation injury. If it is a workers' compensation injury, there can be some specific requirements which are often imposed not just by legislation but also by the insurer in relation to premiums to find alternative roles for the person. That doesn't end if their period of workers' compensation benefits or suitable duties ends, depending on what scheme you're under. What happens after, at any time in relation to anyone that has a disability, is that you have to consider whether a reasonable adjustments can be made to enable the person to fulfil the inherent requirements of their position. This was under the Victorian legislation. If it was under the Disability Discrimination Act federally, it may still have gone the same way, but the fact that there was no express obligation to put in another position under the Disability Discrimination Act might have caused it to go a different way.
And the employee, Mrs. Butterworth, received $13,000 in damages. She received $13,000 for economic loss and $10,000 for her distress and humiliation. This was quite limited compared to some other cases that we've seen, particularly because the employee found a job quite quickly after her termination, and also because she was aware that the termination was going to happen. It didn't come to her as a shock, so that she didn't suffer any kind of psychiatric injury. So her damages were quite limited in this case.